Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and I'm happy to be back after a week off, an unplanned week off. And you may be wondering why I look a little strange. My friend Bill says I should embrace the pirate. Not sure about that, but yeah, had a little bit of a health scare about a week ago, and hopefully I'm on the road to recovery now, but I do have to keep this eye covered at least until I get new glasses, and so I have to look a little strange. This is what happens when you're no longer young. So, but anyway, thank you for joining me today. And I guess kind of, in along with the theme of, mishaps. So I had a guest planned for today. Those of you who saw either my newsletter or the show prompts, unfortunately, he had a family emergency at the last minute and was unable to make it. And so, having been in the military and knowing sometimes you have to shift gears quickly, so I latched on to a topic that we can talk about today that I think you will find worthwhile and interesting. This topic applies not only to the probate and estates realm. It does apply more broadly into the sort of human behavior realm, I guess we might call it. And that is, I want to talk about two methods of what are known as alternative dispute resolution methodologies, okay, ADRs for, I guess that's sort of what they go by, although an ADR also is an acronym for some kind of financial instrument, I think. But in any event, today I'm going to talk about mediation and arbitration. Okay, so as much as we would hope that good, solid estate planning will help avoid disputes, either between heirs or who knows, it could be between a creditor and the estate. It could be between a government entity and the estate, or it could anywhere where there's more than one party involved. There is the possibility of a dispute, and in fact, sometimes I guess even when there's only one party involved, right, we end up disputing with ourselves, not knowing what to do. And so, mediation and arbitration are two ways of handling disputes instead of going to court. Okay, so while a probate is going to require a court filing regardless, that doesn't necessarily mean that everything has to go through the court in order to get a resolution. Alternative methods can be used to resolve disputes that then are taken to the court for approval. Okay, and so and they can be. We'll talk about the advantages to these alternatives, but the reality is hopefully they will save time and or money, right? And when you have an estate at issue, right, the longer it goes on, the longer it will probably be for the assets to be distributed, and the longer it takes to settle a dispute, the more the assets of the estate, whether it's a probated estate or it's an estate in a trust, may get defrayed by the cost of dealing with those disputes before then the remaining assets can be distributed to the heirs or the beneficiaries, depending again on whether it's a probate or a trust. So we're going to look at these two, and normally I would have a little PowerPoint, but there just wasn't time to to put one together when I found out that my guest couldn't make it, and so I'm gonna talk without the PowerPoint. I'm sure you can deal with it, right? So the two alternative dispute resolution processes, again, that I'm going to talk about are mediation and arbitration. Okay, so let's talk about mediation first. Mediation is a voluntary process in which a neutral third party called a mediator helps the disputing parties communicate and negotiate a resolution. Okay, so while the parties may have lawyers helping them out, typically the mediator is acting between the parties themselves, okay, not their representatives, okay? And sometimes mediation will happen with the two parties and the mediator, all three meeting together. And sometimes the mediator will sort of shuttle between the two parties. And by the way, this can be done either in person or online. I know I was involved in a virtual mediation, over a year ago now. Okay. Now, here's a key point about mediation, and that is the mediator does not make a decision for the parties. Okay. The mediator looks for creative ways to help the parties find a resolution to their dispute. Okay. The mediator has no authority to order anything. Okay. There's no mandatory discovery, meaning sharing of information. The mediator has no authority to do any of those things. All the mediator can do is negotiate, encourage, come up with creative solutions. Okay. So here's the I would say the key point in a mediation. Okay. That is to find a mediator who will look beyond the strict letter of the law in finding a solution. So if you're dealing with a mediator, and many of them are lawyers, many lawyers go into mediation, and all they do is talk about, well, the law says this and the law says that. The chances that mediation is going to be successful are lower than if the mediator is looking for ways to solve the whatever the problems are between the parties in a more creative way that may deal outside the legal constraints, but may still be a satisfactory way for the parties to settle their differences. Okay, I have a very good friend who's a mediator, and one of the reasons why he's so good is because he's very creative. And in fact, if you go on my YouTube channel and look for the I did two shows with oh gosh, all of a sudden I'm going up on his name. My friend Raphael Lapin. Okay, Raphael Lapin is a lawyer, but he does not practice law. He is a mediator. That's all he does. And he's mediated small matters and he's mediated huge matters. And his skill comes down to he's able to find areas of mutual interest between parties that allow them to settle disputes beyond what the strict letter of the law might dictate. Okay? All right, so that is mediation. Okay, now, once, assuming parties are able to come to an agreement through mediation, it is not binding in the sense that it has no legal force. Okay, so then in order to make it binding, the parties will put together a stipulation, which is basically something they've agreed to that then gets filed with the court, okay, and is made binding. Okay, so it's not that a mediated solution can never become binding. It's that the mediated solution, it's all by itself, is just an agreement between the parties. It has no legal force. Okay, so after the mediation is done, an agreement can be drawn up. The agreement can be signed by both the parties. Now it's a contract. Okay, and then violation of that contract certainly can be, mediated, arbitrated, litigated, or whatever, and it can be made, like I said, into a court stipulation, which gives it in effect the force of law. Okay, but this mediated solution itself is not a legal solution. Okay, it's not a binding solution, I'll call it. Okay, the other method, the other alternative dispute resolution process that we'll talk about is called arbitration. Okay, now arbitration is also a process in which a neutral third party called an arbitrator listens to evidence, and then the arbitrator makes a decision about the dispute. Okay, notice this is very different than mediation. In mediation, the mediator has no authority to make any kind of resolution, only help the parties reach one. In arbitration, the arbitrator actually will make a decision about the dispute, how it's going to be resolved. Okay, now, excuse me, most of the time, the parties to an arbitration will be represented by counsel. And in fact, their lawyers will probably be the ones presenting the case. The arbitrations that I've been involved in, primarily as an expert witness, lawyers represented the party to the arbitrator. Okay, now you can have what's called binding arbitration, and you can have non-binding arbitration. Okay, depending on the situation, it may be one or the other. Now, having said that, I want to quickly add, there are situations where if the parties go to arbitration, it will be a binding arbitration. So for example, maybe there's some kind of contractual dispute, and in the contract, there is an arbitration clause that says, if there's a dispute regarding this agreement, the parties agree in advance to go to binding arbitration. Okay, in that case, the contract specifies the arbitration will be binding. Now, what does that mean? What that means is the parties are bound by the arbitrator's decision, whether they like it or not. Okay, now, in some cases, the arbitrator's decision cannot be appealed. Okay, so once the arbitrator reaches his decision, done. C'est fini, as the French say. Okay, in other cases, an arbitration decision may be appealable. It's going to depend on the specifics of the case. Okay, all right. Now, in arbitration, generally speaking, there are different arbitration organizations, and they set up rules about things like discovery. Discovery is the process whereby each side gets to learn information about the other side's case. Okay, so in arbitration, discovery is not as formal as it would be in a court proceeding. Okay, however, there typically are some rules about it. okay? And the arbitrator can make decisions that are binding on the parties relative to discovery, okay? As well, it's not unusual, as I mentioned a couple minutes ago, for there to be expert witnesses involved in an arbitration. Okay, whereas in a mediation, you may or may not have expert witnesses, and if you do, they're probably acting on the side. They're probably not, giving any kind of testimony, because mediation doesn't involve testimony. Okay, in an arbitration, the expert witnesses probably they're going to come up with some kind of, initially, probably what's called work product, which means work that's done on behalf of the lawyer, that then, if it's going to be used in the arbitration, that work product will be exchanged with the other side, and then it'll be presented at the arbitration at the time that the expert or experts testify. Okay, now in some cases, the parties may stipulate to a single expert to come up with information that will lead, hopefully, to the resolution of the dispute. In other cases, each side may have their own expert, and then the arbitrator will hear the testimony from both and decide, decide the matter on the basis of that testimony, and of course, whatever else there is to know about the particular case. Okay, so a couple of things to sort of compare and contrast mediation and arbitration. In all cases, mediation is voluntary. Now, arbitration can also be voluntary. However, there is, as I mentioned, there are agreements where if a dispute arises, arbitration is mandated in the contract as the resolution mechanism. Okay, and so in that case, it's not really voluntary, it's required. And a court can also order arbitration to try and settle the dispute. By the way, the court can also order mediation, and in that sense, the mediation isn't voluntary. However, the court-ordered mediation, it's not mandatory in the sense that there must be a mediated solution. It's just the parties are ordered to go to mediation. And after a time, if the mediation can't resolve the dispute, so then it goes back to the courtroom setting. Okay? In both cases, there is a neutral third party, a mediator in the mediation and an arbitrator in the arbitration. Okay, now this is a particularly sensitive issue. So if one party has a relationship with a mediator or an arbitrator, okay, that mediator or arbitrator is supposed to disclose that pre-existing relationship, and it is, by the standards of most, if not all, mediation and arbitration organizations, it would be improper for that individual to agree to mediate or arbitrate that dispute. Okay, so if you're dealing with a reputable mediator or arbitrator, okay, then they will not accept a case in which they cannot be a neutral third party. Okay, I had a situation where somebody was advocating for a particular person to be the mediator, and yet this person had been friends at one time, very close personal friends with this person, right? And so in discussing this, I said, this person does not have the appearance of neutrality, let alone probably the reality. So that mediator is just not going to be appropriate. Okay, so I would say both of those are important. They need to have the reality of neutrality, That rhymes. But they also need to have the appearance of neutrality as well. Okay, when it comes to decision making, this is a big difference. Mediation, the parties will come to a mutually agreeable solution if possible. In an arbitration, the arbitrator makes what is in many cases a binding decision. Okay, cost. Typically, mediation is less expensive than arbitration, which is itself usually less expensive than litigation. Okay, and that's why people typically try mediation, arbitration in lieu of going to court. That's one of the reasons why, is because it costs less. Okay. Another issue is the speed within which, or the speed with which you can get to some sort of resolution. So mediation can be faster than arbitration, and typically will be if it's successful. Okay. Now, arbitration will usually take longer. Okay. But it will usually be shorter than full-on litigation. And that's because of the less formal discovery, the less formal nature of how the hearings are conducted, etc. Okay. And by the way, most arbitration, you never have a jury in arbitration. Let me put it that way. Okay. Now you could have, even in a civil matter, you could, in theory, have a jury, although that's fairly unusual these days. Okay. Now, in an arbitration, typically you're just going to have one arbitrator. Now, there may be a situation, very high stakes arbitration, where you might have more than one arbitrator, like 3 or something like that. That would be very unusual. So, again, one of the reasons why arbitration will typically be faster than litigation is there's just one arbitrator. He hears the evidence in the case and he makes the decision, and, dos vidania. Okay. The last issue I want to sort of compare and contrast is privacy. Okay, so a mediation is more private than an arbitration. And in fact, in most, if not all cases, what happens in a mediation is not admissible in court if, for whatever, let's say the mediation is not successful, and so the parties end up in court. In that case, okay, what happened in the mediation is not admissible. Okay. Now, parties can stipulate to allow something that happened in the mediation to be allowed into court. That's by agreement of the parties. Okay. But in general, what happens in mediation stays in mediation. Okay. As compared to Las Vegas, where what happens in Las Vegas is recorded on computer servers, and the security people watch the particularly funny things that people do later at night in order to amuse themselves. Okay. There is no truth to what happens in Las Vegas stays in Las Vegas. Don't buy it at all. Okay. I've been rear of house in casinos. I've seen the cameras. I've seen the recording devices. Okay. Mediation, though, is a private dispute resolution mechanism. Okay. Arbitration is less private. Okay, especially depending on how the arbitration came about. And what happens in an arbitration, it's not that it's admissible or not in court. It's just if the arbitration agreement provides for appealing an arbitration decision in court, then of course anything that happened in the arbitration will be admissible in the court proceeding. Okay, but in general, arbitration is more private than litigation. Okay, what happens in open court is a matter of public record in most cases. Okay, now there are exceptions where the judge, for whatever reason, doesn't allow the public in the court. There may be sensitivities, there may be a minor involved. Okay, so it's very difficult to make sort of very definitive statements in all of this stuff. So that's why I say mediation tends to be more private. Arbitration tends to be less private. Both of them, though, are typically more private than litigation. Okay. Now, if you have a dispute, which alternative dispute resolution process is better? And the answer is, as you can probably guess, it just depends. Okay. It depends on the nature of the dispute. It depends on the nature of the parties. It depends on how complex the dispute is. Okay. There could be multiple issues in dispute. Okay. And of course, the more issues there are in dispute, the harder it can be to get to some kind of resolution. Okay. Now, having said that, what it really comes down to is the willingness of the parties to really engage and participate in either mediation or arbitration. Okay. So if, one party just does not want to go to mediation, the chances that it's going to work are probably pretty small. Okay. And in fact, I had a mediation like that last year where the party talked a really good game about going to mediation, but when all was said and done, the party didn't have any meaningful participation at all. Okay, the party used it purely as a forum to try and beat up the other side, which in this particular mediation, both parties were represented by lawyers. Okay, and I think that was the party's lawyers sort of modus operandi is let's beat the other party up in mediation, right? And then that party will give up and we'll get what we want. And it didn't work because it quickly became obvious that one of the parties didn't really want to mediate a solution. They wanted to browbeat a solution. Okay, so in order for mediation to work, both parties have to feel like they have a stake and a willingness in substantial participation, dealing with the complexity of the issues, and really searching for some kind of creative solution. If both sides are not committed to that, then the chances mediation will work are reduced significantly. Now, with arbitration, if the parties decide to go to arbitration, especially if it's a binding arbitration, so at that point there is going to be a resolution. Okay, whether now again, if it's required by a contract to go to arbitration, so then that's what they're gonna have to do. If there's no requirement for arbitration, nonetheless, if the parties do agree to go to arbitration, and assuming that they've been properly briefed as to what arbitration means, what it is, how it works, so then you're going to get to a binding decision because the arbitrator is going to make the decision. Okay. All right. So I think that's really. I think that's really all I want to say. And actually that turned out just about right. We're just about at the half-hour mark here. And so anyway, while mediation and arbitration can be used in probate and estate matters, trust matters, etc. Okay, they can really be used in any kind of dispute. Okay, this show talks about trusts and estates, and so I'm talking about it in that context. But really, these alternative dispute resolution methodologies can be used in a wide variety of situations. Okay, and again, I invite you to go to my YouTube channel. I believe it's the second most popular show that I've done. It's one with Raphael Lapin. It was the first show we did together where he talks about how mediation works and how it can be used, how he became a mediator and how he's been able to help people resolve disputes much more quickly, much less expensively through that alternative means for settling disputes. So I invite you to take a look at Raphael's show, and he's quite the raconteur as well. So I think you will enjoy listening to him speak as well. So that's what I have for you today. Thank you very much for joining me. I'll see if I can get Courtney Rollins rebooked on a later show. Hopefully his family situation turned out okay. We certainly wish him well in that. Just to mention before I sign off, tomorrow is Business Lessons from the Military. We're going to be wrapping up our latest segment on Marine Corps warfighting doctrine, okay, the principles of war applied to business. And we're going to be talking about combat arms. Okay, so what do combat arms have to do with business? Tune in tomorrow at 11 a.m. Pacific time, and you will find out. And then on Wednesday at 12:30 p.m. is my show, People Making Money. And we're going to talk about what insurance do you really need? Okay. I think if you listen to advertisements, you'll say, like, oh, you got to have this insurance, you got to have this insurance, this one's mandated, that one's mandated. We're going to go through all that and talk about what do you really need? What, we're going to get into a bit of the nitty gritty about what is insurance really about and what do you really need? When do you need it? Do you always have to carry every type of insurance your entire life? Right? It's a very expensive proposition. I remember when I had my real estate business, I used to joke that like my first month of the year was devoted to paying insurance for the rest of the year because I had to have so many different types of insurance coverage. And insurance has only gotten more expensive since then. So we want to be very strategic about what type of insurance coverages we have. So we are taking care of mitigating the risks that we need to take care of without paying a lot of insurance premiums that are unnecessary. Okay, so we'll talk about that on Wednesday, People Making Money, 12:30 p.m. Pacific time. And then next week, we will be back again on Monday at 10 a.m. for the next episode of Trusts and Estates Weekly. So thanks again for watching. Looking forward to seeing you later this week and signing off. Marie, darling, you are my belle. All the best, folks.